are that different. We care about property rights. We care about checks on government. I agree with you. I usually think of Liberals and NDP are the parties of good intentions. For me, what counts is good results. And what Evan said, what I'm saying is South Saskatchewan RAC report, Lower Athabasca draft regional plan, you're getting results. Look what's been done, not on what might happen. I think our disagreement is more political. Which political party in this province is going to strike the right balance on environment development and protect property rights? We've heard that. The Wild Rose Alliance has run a very slick campaign of misinterpretation, misinformation, and scared the hell out of the Wild Rose. Okay. I'm not a newcomer to politics. I worked with the Reform Party, with people that you supported, Preston Manning, Stockwell Day, Stephen Harper, back in the Reform Party days when we were in the minority, and I know what opposition parties have to do, because I've been there. In fact, I'm the only member of our caucus that has been there. And you exaggerate, you take out of context, and I'd have to admit in this case, the Wild Rose has done a pretty good job. But at the end of the day, the facts are simply not on the side. And I think if you have an open mind, you listen to us tonight, you would get a clear picture. Now, for 40 years, people in rural Alberta, rural landowners, farmers and ranchers like yourself, most of you have supported our party, the PC Party of Alberta, and we've supported you. Bill 36 doesn't change that. The last thing we want to do in a caucus with almost half of our caucus are rural landowners, are weaken property rights, and Bill 36 does not do that. In the 21st century, the greatest threat to landowners is not expropriation, it's this regulatory taking and having environmental policy run by interest groups through the courts. Bill 36 addresses both of those. Now you're here, and I appreciated that you respect our intentions, and I respect your intentions. You care about Alberta's future, so do we. You've raised concerns about Bill 36 and property rights. We've listened. We've made some amendments that clarify things and add some new provisions for property rights in Bill 10. You want local decision making and democracy? Well, I'd say tonight it's pretty local. Here we are in Eckville. Last month we were in Balzac and High River. And that's the difference. When you call, and you don't like what's going on in Edmonton, we come back. You know us. There's Luke. There's Ty. There's Ted. There's Evan. You can get us in here and give us hell. Okay? You've done a pretty good job tonight. But you don't want to be in the position. You don't want to be in the position, you've seen it, where judges make policy. I mean, forget about bringing the judges to Eckville or High River. So you called us, we came, you had questions, we've given you answers. I would say this is democracy in action. Evan and I are proud to be here as part of it, and we thank the Chamber for organizing it. Thank all of you for coming. Thank you.
Thank you, Ted and Evan. Ladies and gentlemen, a couple of things you need to remember tonight. One that's really important, this is the first time that I know of that we've been able to get Keith Wilson and the government in the same house to talk about this. Something else that's really important, we have a lot of MLAs here, and I can tell you that the smoking pen is really working up here. So they made a lot of notes, and I'm sure they're going to go home and read them over and take it under advisement. So please be courteous. Keith.
Thank you. Hear, hear.
Joe, can you go forward to a slide that says a better way forward? Now, and don't look at the slide yet, I want to make a couple of points. First of all, with all due respect, I mean, I've been accused of fear-mongering. I don't think that's what I've been doing. I've been trying to warn you. I still remind you, and it was funny, on Wednesday they announced on Tuesday, was the 5th of April, that they were rescinding these oil sands lease, and on Wednesday I got calls from 3 different reporters. The first thing they said, before I could say anything, was, "You were right." They didn't let me get to say, "I told you so." And they asked me if I was surprised. And I told them I was. Even though I told you that the government had given itself the power to do this, I was still surprised they actually did. So that's cause for concern. And what I don't think is getting through to the government is that what is making people uncomfortable is the fact that the government has viewed it to be acceptable to give itself this kind of power over your lives, your business, and your property. When I was at Osgoode Hall Law School, I had the fortunate opportunity of being taught constitutional law by the then senior constitutional litigator, did all his practice in the Supreme Court of Canada, happened to be former, at the time he was former Attorney General of Ontario. And I actually wrote a paper on, opted for a research paper instead of doing the 100% final, where I did an analysis of federal jurisdiction vis-a-vis provincial jurisdiction on matters of the environment. And I can tell you, as somebody who's studied the case law as it has evolved, that this notion that this legislation is needed to somehow stop Ottawa from taking control of Alberta and its resources is pure legal nonsense. And I can cite the cases if I need to. It is true that Ottawa can step in if Alberta doesn't adequately protect certain resources within the jurisdiction, such as the waters. But you don't need Bill 36 and the power to rescind things to do that. That's why we have the Environmental Protection Enhancement Act. That's why we have the Water Act. And that's one of the things that's troubling to me, is when I read this legislation, and particularly when I read the draft South Saskatchewan plan, it repeats. It says we need to, through a regional plan, develop guidelines and frameworks to have groundwater studies done before people drill water wells. Well, I know there's a whole bunch of you in here who probably know what a Q20 test is and had to pay $17,000 or $20,000 to a hydrologist to get a water license. It's already there. So I look at this stuff and I say, whoever's drafting this does not seem to understand the legislative framework we have, and to suggest that somehow this must be done and we must sacrifice ourselves and all of our rights to save ourselves from Ottawa is not a valid legal statement. You know, I came across, when I met with Minister Knight, when he asked me to come meet with him a few weeks ago, I asked him, I said, you know, I researched to see if there's any other jurisdiction that's tried to centralize decision and planning authority in the capital city and have total control over private and public lands, whether it's occurred anywhere. Because I said, all my research took me to Eastern Europe. That's the only place I could find it. I'm sorry. And I said, so I asked him, is there somewhere else that maybe it was done that I missed? And as lawyers, we don't like to ask questions we don't know the answer to, but I rolled the dice. And he said Oregon. And I said, well, I missed Oregon. I didn't know Oregon had done this. So you guys, when you get home, research what happened in Oregon. And in fact, there's an audio tape of the governor in 1973 saying exactly what you heard here tonight. Our state is growing. Our population is growing. We're not getting any more land. The government needs to put in a land use framework. And they did. And it's been a disaster. Their first amendment to try and fix it was to put in the concept of compensable taking. I didn't use that word tonight. Dr. Morton did. Section 19.1 of Bill 10. We are repeating on fast forward the mistake of Oregon. Oregon's land use framework experience has been a complete failure. It's devalued property, it's sterilized land, it's led to arbitrary problems, and no other state in the United States has chosen to follow it, except this government in Alberta. A better way forward. There's nothing wrong with these goals. We can do better land use planning, but we don't need central planning. We used to have regional planning commissions from 1955 until 1995. And there's lots of people, including our MLAs, that know that because they were involved in municipal politics at the time. The government of the day made the decision to get rid of them primarily for cost-saving reasons, I believe, at the time. And I was invited to speak to the Alberta Institute of Planners. And they told me that a reason you see a lot of the disconnects that we're seeing in some of our planning in the province is because we got rid of the regional planning commissions. But remember, they were truly regional. You had 5 or 7 municipalities. They each picked one of their councillors. They went to the regional meeting. Okay?
So it was true.